inmates can cause.
Mr. Chairman.
I call the Honourable Minister Anne Tolley.
Mr. Chairman, so I have taken some advice in answer to Mr. Cheval's query, and they assure me that any legal action would have had to have been lodged on or before the 12th of February when the SOP was tabled. And again, that it's not possible to question the validity of disciplinary proceedings without also questioning the validity of the rules or regulations. So that advice then says that this SOP rules that out. I thank the member.
The question is, the Honourable Member Charles Cheval.
Look, I am grateful to the Minister for taking that advice. To be as clear as I can be, my concern is twofold. First of all, the definition of proceedings. That's, I think, pretty clearly limited to proceedings in court. My point was really that there are other types of remedies or causes of action or procedures open to people who wish to challenge the validity of regulations. And I'm not sure that subsection 2 does extinguish all those types of proceedings. Minister's nodding her head, so obviously that's deliberate, but I think we should be clear that that is the case. The second concern I had, and if I didn't express it clearly, I apologise, was what about proceedings that don't make a headlong challenge to the rules and regulations that are being validated by this supplementary order paper, but which rely on independent causes of action, such as an attempt to, I think the examples I used earlier were seek judicial review in and of itself by virtue of either Section 21 or 27 of the New Zealand Bill of Rights Act, or seek agent damages. Now, if the officials have considered those expressly and think that they are excluded, well and good. But I just want us to be clear that we're doing, that the Minister's proceeding on the basis of that very clear advice, if that's what she is doing.
I call the Honourable Member Ian Lees-Galloway.
Thank you very much, Mr. Chairman. New Part 3, as set out in the Minister's supplementary order paper, makes some consequential amendments to the Smoke-Free Environments Act. Specifically, it removes references to prison in the interpretation section and amends the definition of workplace. It also repeals Section 6A, which referred to the procedures that had to be put in place in prisons in order to ensure that prisoners who were smoke-free were able to have, I suppose, quiet enjoyment of their prison cell and be able to be smoke-free themselves without other prisoners impinging upon that. And it is it's because of that, and also the fact that prison officers and corrections staff working in prisons are able to now safely work in their workplace whilst being smoke-free, that we on this side of the House do support the concept of smoke-free prisons. That I want to make that quite clear, that although we have some real problems with the way this legislation is being passed, the fact that this is a supplementary order paper being introduced to tidy up a mess caused by Judith Collins, a fact which has been well canvassed by many members in the House this evening, but also the fact that this has been introduced as a supplementary order paper without much warning from the government, without the opportunity for the Select Committee to give it the scrutiny that it really requires, without the ability for the Attorney-General to offer an opinion regarding the Bill of Rights Act. And it is quite possible that this supplementary order paper does contravene, on the face of it, the Bill of Rights Act, and that may also open up the government to future complaints, possibly to the Regulations Review Committee. I don't know. There seems to be a lot of holes in this supplementary order paper, and it has not received the scrutiny that it really ought to have, and therefore we cannot support it, sir, because we could just be leaving the New Zealand taxpayer vulnerable in the way that Judith Collins did in the first place. That we may find, because neither the Attorney-General nor the Select Committee has been able to give this supplementary order paper the scrutiny necessary, that this just leaves the taxpayer as vulnerable as they were in the first place. Mr. Chair, I just want to make one point, and that is that although we are supportive of the ban, the smoking ban in prisons, what this effectively is a form of prohibition. Within a prison, this is a form of prohibition. And what you get when you introduce prohibition is a black market. And we've known for some time. There was an article, the article that I was able to reference this evening was in the New Zealand Herald. I think there were others showing that the price of an illegal packet of cigarettes or an illegal quantity of cigarettes or tobacco in prisons has now reached $500. Now that is a direct consequence of introducing prohibition. Now that's not money that the government is able to collect to use to reduce the harm caused by taxpayers. That money is going directly probably to organised crime and the relatives of prisoners. And that is an unintended consequence of introducing prohibition. So although we're supportive of the measure, I think it's important to point that out, that when we're considering effective ways to deal with substances like tobacco, prohibition isn't always the best way forward. Mr. Speaker, whilst we can appreciate what the Minister is trying to achieve with these amendments in the new Part 3 that will amend the Smoke-Free Environments Act, as I said, we are unable to condone this legislation because all it is a backside covering job for the government to try and tidy up the mess caused by Judith Collins. We don't think that it's effective. We think that it has far too many opportunities for future litigation by learned prisoners such as the gentleman whose name again escapes me, Arthur Taylor, who's been able to, who's not a lawyer and has been able to outsmart the Minister.
I call the Honourable Member Colin King.
I move that the question be now put.
The question is that the question be now put. As many of that opinion will please say aye. The contrary, no. The ayes have it. Party vote call for. Clerk will please conduct the party vote. Thank you.
New Zealand National.
59 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party.
14 opposed.
New Zealand First.
7 votes opposed.
Māori Party.
2 votes in favour.
Mana.
1 opposed.
Act New Zealand.
1 in favour.
United Future.
1 in favour.
Brendan Horan. Any other votes?
Honourable Members, the ayes are 63, the noes are 56. The question will be put. The question, therefore, is that new Part 3, as set out on Supplementary Order Paper 171, be agreed to. As many of that opinion will please say aye. Aye. Contrary, no. The ayes have it. Party vote has been called for. Clerk will please conduct the party vote. Thank you.
New Zealand National.
59 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party.
14 opposed.
New Zealand First.
7 votes in favour.
Māori Party.
2 votes opposed.
Mana.
1 opposed. Apologies.
Act New Zealand.
1 in favour.
United Future.
1 in favour.
Brendan Horan. Any other votes?
Honourable Members, the ayes are 68, the noes are 51. The motion is agreed to. The question now is that clauses 1 and 2 stand par. All those in favour, please say aye. Aye. The contrary, no. The ayes have it. Party vote call for. Clerk will please conduct the party vote. Thank you.
New Zealand National.
59 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party.
14 opposed.
New Zealand First.
7 votes in favour.
Māori Party.
2 votes opposed.
Mana.
1 opposed.
ACT New Zealand.
1 in favour.
United Future.
1 in favour.
Brendan Horan. Any other votes?
Honourable members, the ayes are 68, the noes are 51. Clause 1 will stand par. The question now is that the Minister's amendments set out, the Minister's amendments to Clause 2 set out on SOP number 171 be agreed to. All those in favour, please say aye. The contrary, no. The ayes have it. Party vote call for. Clerk, please conduct the party vote.
New Zealand National.
59 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party.
14 opposed.
New Zealand First.
7 votes opposed.
Māori Party.
2 votes opposed.
Mana.
1 opposed.
ACT New Zealand.
1 in favour.
United Future.
1 in favour.
Brendan Horan. Any other votes?
Honourable members, the ayes are 61, the noes are 58. The Minister's amendments are agreed to. The question now is that Clause 2, as amended, stand part. All those in favour, please say aye. Contrary, no. The ayes have it. Party vote is called for. Please conduct a party vote. Thank you.
New Zealand National.
59 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party.
14 opposed.
New Zealand First.
7 votes in favour.
Māori Party.
2 votes opposed.
Mana.
1 opposed.
ACT New Zealand.
1 in favour.
United Future.
1 in favour.
Brendan Horan. Any other votes?
Honourable members, the ayes are 68, the noes are 51. Clause 2, as amended, will stand par. Honourable members, I will report this bill with amendment presently.
The House is resumed. Mr. Chairman.
Mr. Speaker, the committee has considered the Corrections Amendment Bill and reports.
Reports on this amendment.
The committee has considered the Corrections Amendment Bill and reports it with amendment. The committee has also considered the Privacy Information Sharing Bill and reports no progress. Mr. Speaker, I move that the report be adopted.
The question is that the report be adopted. Those of that opinion will say aye. Contrary, no. The ayes have it. The Corrections Amendment Bill is set down for third reading next sitting day, and the Privacy Information Sharing Bill is set down for further consideration in committee next sitting day, and the House will stand adjourned until 2 p.m. tomorrow. Good evening, everybody.